So in this video, I want us to shift our attention to discharge of a contract. Now, what is the meaning of discharge of a contract? You see, a contract is discharged when the obligation created by the contract comes to an end and parties are released from further performance. So that once discharged, parties are no longer bound to perform the contract, since rights and obligation under the contract have actually ceased. However, liability after discharge depends on the method of discharge. So let's look at the method of discharge of a contract. Now, a contract may be discharged by express agreement, by performance, by impossibility, which is frustration, by breach, and also by operation of law. Now, let's look at discharge by express agreement. You see, discharge by express agreement occurs where parties agree to terminate the contract. And the principle is that what is created by agreement can also be extinguished by agreement, so that the agreement may be oral or written and the mutual promises act as consideration. Now, let's look at the types of discharge by agreement. Now, the first type of discharge by agreement is a bilateral discharge. Now, a bilateral discharge happens where neither party has performed the contract, so that the obligations are executory. That is, obligations are still pending, in that both parties agree not to perform and both parties are actually released. And a good example is if A agrees to sell B a laptop next week before delivery and payment, and both agree to cancel the contract, then the contract ends. Now, that is a bilateral kind of discharge. Now, the second type of discharge by agreement is a unilateral kind of discharge. Now, unilateral discharge occurs where one party has already performed wholly or partly, so that the performing party releases the other party. So what are the forms of unilateral discharge? Now, the first form of unilateral discharge is contract under seal. Now, a sealed agreement does not require consideration, so that once executed, it is actually binding. So that if a landlord signs a sealed release for giving rent arrears, then the tenant is actually discharged. The second form of unilateral discharge is novation. Now, novation is substitution of an old contract with a new contract, so that the old contract ends and a new contract begins. So that if A owes B 50,000 shillings and they agree that instead of money, A will transfer a motorcycle, then the old contract ends and a new contract begins. Now, that is what we call novation in contracts. The third form of unilateral discharge is accord and satisfaction. Accord and satisfaction is buying release from obligation by giving fresh consideration. So that accord means agreement to accept something else, and satisfaction means the new thing given. So that if A owes B 100,000 shillings and B agrees to accept 60,000 shillings immediately and A pays immediately, then the debt is actually discharged. Now, let's look at discharge by performance. You see, a contract is discharged when parties perform their obligations fully. Now, the rule is that performance must be exact and complete. And this is called, the doctrine of precise and exact performance. So that at common law, a party must perform strictly according to contract terms. If you look at the case of Carter versus Powell, the facts of this particular case were that Mr. Carter agreed to work on a ship journey from Jamaica to Liverpool for 30 guineas. So he died before arrival, and his wife claimed payment for work done. And the issue in this particular case was, could payment be made for incomplete performance? And the rule is that a contract requiring complete performance must be performed exactly. And the application is that Qatar did not complete that particular voyage. And so completion was the condition for payment in this particular case. So the conclusion of this particular case was that no payment was due. So that if a painter agrees to paint your entire house for, let's say, 50,000 shillings, and he paints half and disappears, under strict rule, there is no payment for him. Be that as it may, there are exceptions to the doctrine of precise and exact performance. So that to reduce unfairness, courts created, exceptions. And the first exception the court created is what we call divisible contracts. You see, some contracts can be split into parts so that payment is made according to completed portions. If you look at the case of Ritchie versus Atkinson, the facts of this particular case was that a contract involved carriage of goods payable per ton, and the carrier transported less than agreed. And the issue was, could he claim payment? And the rule is that if contract is divisible, then payment may be made for complete portions. And the application of this particular case was that payment depended on quantity carried. The conclusion of this particular case was that payment was allowed on quantum merit. Now, if a border rider charges, let's say, 100 shillings per kilometer, and he transports goods for 5 kilometers, then he earns for 5 kilometers. So that even if the total journey was 10 kilometers, he is only going to earn for the 5 kilometers he transported the goods. The second exception the court created is substantial performance, in that where major obligations are completed, then payment is allowed less of defects. If you look at the case of Merchandise, Metha and Company versus Baron Verhagen, the facts of this particular case was that the plaintiff built the defendant's house. Some structural defects existed, and the defendant refused the final payment. And the issue was contractor, that is the contractor, entitled to payment? And the rule is that substantial performance entitles payment less of the cost of correcting defects. And the application of this particular case was that the house was substantially complete, and so the plaintiff was only entitled to final installment minus the repair cost. So that if a tailor makes your suit perfectly, except for one loose button, then it should still be paid minus the repair cost. The third exception the court created is partial performance if accepted, in that where the other party accepts incomplete work, payment may actually arise, but acceptance must be voluntary. If you look at the case of Sumter versus Hedge, the facts of this particular case was that the plaintiff agreed to build houses, and so he abandoned midway, and the defendant completed the work, and so the plaintiff claimed payment. And the issue was, could he recover? And the rule is that partial performance is only payable if accepted voluntarily. And the application of this particular case was that the defendant had no real choice but to continue, since there was no voluntary acceptance. And the conclusion of this particular case was that there was no payment. So that if a mechanic repairs only half your car and then disappears and you finish the repair elsewhere, then he cannot demand for full payment. The full exception the court created is prevented performance, in that if one party is willing to perform but is stopped by the other party, then payment may actually be recovered. If you look at the case of Plaintiff versus Colburn, the facts of this particular case were that the plaintiff was contracted to write a book. And so the defendant cancelled after research had begun, and so the plaintiff sued. And the issue was, could he recover? And the rule is that if prevented from performing, a party may claim for work done. And the application of this particular case was that the plaintiff had already invested time and labor, and so the defendant, caused, the termination. And the conclusion of this case was that the plaintiff was awarded payment. So that if a photographer is hired for a wedding, and after preparing equipment, the client cancels last minute, then the photographer can still recover preparation costs. The fifth exception the court created is time of performance. You see, contracts must be performed within agreed time or within reasonable time, so that where time is essential, failure to perform on time discharges the contract. And this is called, time being of the essence. If you look at the case of Vanessa versus Poppert, the facts of this particular case was that the defendant ordered furniture for delivery on 30th April. And so delivery was delayed and extension was given to 10th May. And it's still delayed. So the buyer cancelled, but furniture was delivered later and the seller sued. And the issue was the buyer bound to accept late delivery? And the rule is that where time is of the essence, delay amounts to breach. Now, the application of this particular case was that the seller failed within agreed and extended period. The conclusion of this particular case was that the buyer was not bound to accept. So that if you order, for example, a wedding cake for Saturday, and the baker delivers on Monday, then it is too late, so that the contract is actually discharged. Now, let's look at quantum merit. You see, quantum merit means as much as deserved. That is payment for work actually done. Now, quantum merit applies where contract is divisible, where there is substantial performance, where there is prevented performance, and where there is accepted partial performance. So that if a plumber repairs half your pipes before you stop him, and you accepted the work, then he may recover reasonable payment. So here's a quick summary of what we've discussed so far. You see, for a discharge by this agreement, you need to remember BUNA, and B is for bilateral, U is for unilateral, N is for novation, and N is for accord and satisfaction. For discharge by performance, the general rule is that it must perform fully. In the case of Carter versus Powell, the rule was actually exact or exact, performance. So the exceptions that we've covered, you must remember, DSPPT. And D is for divisible contract, S is for substantial performance, P is for partial acceptance, P is for prevented performance, and T is for time of performance. Now, the golden rule is that you must ask, has the contract ended? If yes, how? Is it through agreement? Is it through performance? Is it through frustration? Is it through breach? Or is it through the law? Then, when you answer those questions, you must determine, the consequences. If it is your first time here, make sure to subscribe and to follow this channel for more legal lessons. My name is Biketi, and see you in the next one.